Good afternoon. Good afternoon, everyone, and welcome to the Labor and Employment Practice Group panel. Sorry for the delay in starting. Some technical problem with our live streaming, which I don't know much about, but that's why we're late. But we have everybody assembled here. Before we start, I would like to do a quick advertisement about the Labor and Employment Practice Group. This is the time of year where we're always looking for new volunteers to serve on our executive committee. So if you practice in this area or are interested in labor and employment law, please be sure to talk with Dean Reuter at some time during the Federalist Society Convention. We have a number of members of our executive committee who can no longer serve because they're in the administration, including Billy Manuel here in front, who is one of the newly confirmed National Labor Relations Board members. We have an extraordinary panel today. I think it might be the first time when we have the heads of all three key employment agencies who are going to talk to you. Our moderator today, who I'm going to introduce, is Judge John Bush, who was confirmed in June of 2007 to the Sixth Circuit with his chambers in Louisville. Prior to joining the court, he was a partner at a law firm in Louisville, where he was also co-chair of the firm's litigation department. Judge Bush and his wife were instrumental in founding the Louisville, Kentucky Federalist Society, which is really great. I don't think they had a Federalist Society when my husband clerked there in the early 1990s. He is a graduate from Vanderbilt and Harvard Law, which is where he met his wife. So this is another Federalist Society couple, as I am proud to say. So Judge Bush, thank you for joining us today as our moderator.
Thank you so much for the introduction. It is my distinct honor to introduce our next speaker, the 27th and current Secretary of Labor, Alex Acosta. Secretary Acosta is the son of Cuban immigrants. He grew up in Miami and was graduated from both Harvard College and Harvard Law School. Following a clerkship with then-Judge Samuel Alito, Secretary Acosta worked in private practice at Kirkland & Ellis. He then served in 4 capacities in the administration of President George W. Bush. First as Principal Deputy Assistant Attorney General in the Civil Rights Division, next as a member of the National Labor Relations Board, followed by service again in the Civil Rights Division as Assistant Attorney General, and finally as the United States Attorney for the Southern District of Florida. Secretary Acosta also taught at George Mason University School of Law, which of course now is the Antonin Scalia Law School. After moving back to Miami, Secretary Acosta entered academia full-time. Following his service as United States Attorney, he became Dean of Florida International University College of Law. He was confirmed to the Senate in his current position in April of this year. Secretary Acosta has called for federal reform of occupational licensing laws, which of course are the rules that prohibit people from working in certain fields without a government entity's permission. He's also promoted President Trump's apprenticeship initiative, and he has stated that apprenticeships could boost wages and give potential employees the skills they need to fill jobs. During the confirmation process, one of his former students described Secretary Acosta, then the law school dean, as follows. Dean Acosta is more than a dean for law students. Throughout his tenure, he has been like a father, mentor, and friend for students, and his deep passion for the law, labor, and education has helped the students he has counseled throughout his career. So we're very fortunate to have a public service servant of such character to speak with us today. Please join me in welcoming Secretary Acosta.
Good afternoon, and thank you for the introduction. Let me just say it's wonderful to be here. I'm having flashbacks at other times when I've had the opportunity to speak to the Federalist Society. And at every opportunity, I just think it's wonderful to see old friends, to walk the halls and engage in meaningful debate, discussion. Tonight, we're going to hear from now Justice Gorsuch, and I think we're all looking forward to that. A few months ago, I spoke to the Federalist Society chapter here in Washington. And then I spoke about administrative rulemaking. The gist of my discussion then was that the prior administration used interpretive guidance to change substantive rules. Doing so circumvents notice and comment rulemaking, and that those of us in government have a responsibility to exercise restraint and decline to govern by administrative fiat. There's a stark contrast between interpretive guidance, like the Labor Department's opinion letters, which inform the regulated public of how the agency will apply the law to a particular set of facts, and executive overreach inherent in the use of interpretive guidance in its many and sometimes hidden forms, whether it's in practice manuals, guidance letters, sub-regulatory action is sometimes difficult to find, and to use it to set substantive policy is simply wrong. And that is one of the reasons why we rescinded sub-regulatory guidance, such as the joint employer and the independent contractor guidance at the Department of Labor. Now, today I want to talk about something somewhat different and something very important, and that is the topic of excessive regulation. President Trump has committed, and rightly so, to roll back unnecessary regulation that eliminates jobs, that inhibits job creation, or that imposes costs that exceeds benefits. American workers and families deserve good, safe jobs, and unnecessary impediments to job creation are, simply put, a disservice to all working Americans. That's not to say all regulations are to be eliminated. Common sense regulations, particularly those that serve to address health and safety concerns, have an important place in protecting Americans. There is, however, simply put, too much regulation. Regulations often merely enact through executive fiat that which could not be adopted through the legislative process. Regulations often serve the interests of special interests. They protect special interests from competition. And regulations are, again, simply put, expensive. Regulations create costs at every step of the regulatory cycle. Writing and enforcing regulations cost taxpayer dollars. Regulated parties must hire lawyers to submit comments, many of you in the room, to interpret the regulation once they've been issued, to advise on compliance, and to defend against protracted and expensive litigation concerning the regulations. And by restricting the range of actions regulated parties must take, regulations can force businesses and individuals alike to forego new ventures, they can impede innovation, and they reduce American competitiveness on the global stage. All of these dampen economic growth and divert funds that employers could otherwise use to hire new employees, to offer more workplace education, or to increase wages. The costs to regulations are simply staggering. In fiscal 2016, federal agencies issued over 40 so-called major rules. Major rules include those that have an annual effect on the economy of 100 million or more, or that meet other substantial criteria. And so that was 80 in 2016 alone that have an impact of 100 million or more, and that was only a subset of the federal regulations issued that year. It's difficult to estimate the number of good, family-sustaining jobs that regulations like this have eliminated. One study attempted to do so and estimated that the annual regulatory compliance and economic impact of federal regulations was just under $2 trillion a year. The problem occurs when those in power do not apply a reasonable regulatory standard, and the economic costs have a disproportionately negative effect. And so rolling back regulations that impose unjustified costs or that simply ignore costs is one key to deregulation. Now, costliness is certainly the most common rationale for deregulating, and it is a good one. But there's a second rationale that, while less frequently invoked, cannot be ignored. And that second rationale is what I'd like to focus on today. And that is deregulation to preserve liberty. Liberty appears in the Declaration of Independence, in the Constitution, and in the Pledge of Allegiance. But for all the administrative lawyers in this room, how often have you seen the word liberty appear in an OMB analysis or a cost-benefit regulation? Right? As policymakers focus on the rule's economic costs and benefits, the rule's impact on liberty gets lost in the shuffle. That's somewhat understandable because it's easier to analyze a rule's economic costs and benefits than it is to analyze a rule's impact on liberty. Economic costs are suitable for quantitative analysis. Numerical costs form the basis of technical analysis that all persons, left, right, conservative, liberal, can understand. And though they can argue their points, though they can argue about the numbers and the definitions and the assumptions, those arguments are channeled and they are contained. Rescinding a regulation to promote liberty, however, inevitably requires a qualitative analysis, that is, a value judgment. Rescinding a regulation in the name of liberty requires assertions about the nature of liberty, the role of government, and the principle of self-government. Rescinding a regulation in the name of liberty calls for an evaluation of liberty compared with and in light of equality, safety, accountability, prosperity, and other values. Values that modern society directs to a philosophy class or perhaps a political science class, and certainly not the Federal Register. But liberty and other values are not simply abstruse philosophical terms. They are at the heart of the American experiment. They're what makes America different and exceptional. And exceptional is a word we should not shy away from. If liberty is sufficient to form the foundations of our nation, then liberty should be sufficient to form the basis for changing or rescinding a regulation. So I'd like to go back to one of our very first deregulatory documents, back to first principles, so to speak. And I'd like to posit that that document's the Declaration of Independence. It asserted America's intent to eliminate regulations that impinged on mankind's inalienable rights of life, liberty, and the pursuit of happiness. What follows those memorable words is a long list of grievances that, in the opinion of our founders, justified the American Revolution. Some of those grievances complain of Britain's economic regulation and maltreatment of the colonies, but many more indict Britain's regulation of and interference with the liberty of Americans, the ability both of individuals and of the colonies as a whole of society to govern themselves. The key is this: when we focus only on the monetary cost of regulations, we implicitly assert that man is an economic being and only an economic being. The economic aspect of life is tremendously important, but it's not the only or even the most important aspect of life. Freedom of expression, freedom to worship in accordance with one's conscience, safety from arbitrary government action, the right to choose our leaders, and to make certain decisions about the way we live our lives. These are what make America exceptional, the envy of the world. And a regulation that interferes with any of these core American liberties should be ripe for deregulation, even if it does not impose unjustified economic costs. And so I'd like to offer some examples, a small selection, if you will, to sort of put this in the context of regulations at the Department of Labor. The Persuader Rule, issued last year, required many individuals to disclose when they provided legal advice to employers involved in a union organizing election. The effect of the rule was to discourage employers from consulting with counsel. As everyone in this room, I hope, knows, the freedom to consult counsel of choice has been and should be sacrosanct in the American tradition, and for good reason. Indeed, the American Bar Association, even the American Bar Association came out in opposition to the Department of Labor's Persuader Rule, based on its concerns that the Department of Labor was infringing on the attorney-client privilege. We at the department have published a notice of proposed rulemaking to rescind this rule. And I would posit that the issue here is not merely one of the cost of the paperwork required to fill out the disclosures and to complete and file what is necessary under the Persuader Rule. An issue, you could argue the issue, is one of principle and one of liberty. Revisions to the tip credit rule are another example. That rule is on the spring regulatory agenda. This rule was issued in 2011 and effectively bars all employers from agreeing with their employees to allow the sharing of tips between employees who usually receive them, the front of the house, and employees such as cooks, dishwashers, and other low-wage workers who traditionally work in what's called the back of the house. And it prohibits this even if full minimum wage is being paid. A number of courts have expressed serious concern with the rule and even struck the rule down because express authority was not granted to the department by Congress to regulate in this area. Congress granted express authority to regulate this issue only if the employer used what is known as a tip credit against minimum wage. What the department did in 2011 is infer authority to regulate from Congress's failure to affirmatively prohibit regulation of employers who already pay the minimum wage, which is a different approach to administrative law and one that I'm not going to get into today. But leaving that issue aside, leaving the issue of whether congressional silence is in fact a grant of authority, rather than taking away money, what the tip credit prohibits is transferring money between employees, transferring money from the front of the house to the back of the house. So in the scoring mechanism, the rule's economic costs are much, much less than what is called a transfer cost, which isn't an economic cost. Now, the policy issue in this rule, I would argue, again, is not primarily one of economics, but rather one of liberty. Should we be wary of regulations that fail to respect the liberty of employers and employees to bargain for a mutually beneficial arrangement if they wish to do so? Currently, there's a circuit split between the 9th and the 10th circuits on the tip rule's validity, and certiorari petitions are pending at the Supreme Court. The Joint Employer Guidance offers a third example. The Joint Employer Guidance, adopted toward the end of the prior administration, stated that one business could be liable for the actions of another business if they were a joint employer by virtue of indirect control. And so as I was looking at this, I came across an amicus brief that I think sort of encapsulates what joint employer was about. It was an amicus brief that was filed by Microsoft. You see, in 2015, Microsoft announced a new corporate responsibility policy. Microsoft would do business with large suppliers only if the suppliers provided certain employees with at least 15 days of paid leave annually. It's certainly Microsoft's prerogative to have a corporate responsibility policy, to ask its suppliers to enact this policy. And it's also the supplier's prerogative to have the choice of adopting the policy and doing business with Microsoft, of negotiating, or of ceasing to do business with Microsoft. A government rule that grounds liability in vague notions of indirect control, however, generally ends poorly. And so shortly after Microsoft announced its new initiative, a union representing employees of one of Microsoft's suppliers demanded that Microsoft engage in collective bargaining with that supplier's union. Now, citing Microsoft's paid leave eligibility criteria for suppliers, the union argued that Microsoft was now a joint employer of the supplier's employees, and thus that Microsoft was jointly liable for the actions of its suppliers. The Department of Labor has rescinded this guidance. A similar issue is now pending at the NLRB. Now, let me just say this. The joint employer guidance may be good policy, and some may agree with it, or it may not be good policy, and some may disagree with it. But regardless of economic calculus, the joint employer doctrine certainly impinges on freedom of contract and changes long-standing notions of corporate law. If changes such as joint employer liability are to be made, they should generally happen through the democratic process. They should happen through a legislature, through Congress, and not by regulation, and certainly not by sub-regulatory guidance, as was the case here, that never underwent public notice and comment. Changing substantive law without following the procedures that the people have put in place through Congress, AKA the Administrative Procedures Act, and without giving the public a chance to comment on the proposed change, does not respect democracy, does not respect liberty, does not embrace self-government. It does not reflect the rule of law, but rather the rule of man. That is why we've rescinded guidances, and that is why we're looking at many of the other similar sub-regulatory matters. We're committed to changing substantive regulation through the processes that Congress has enacted. So let me wrap up by saying this. My goal here tonight was to offer an additional layer of analysis for what I believe should be a national discourse on deregulation. As I was thinking about deregulation and the rules, it struck me where we started. You often don't see them talked about in the context of liberty, of values. The natural approach the lawyer takes is what the lawyer is familiar with, which is to look at it in terms of cost-benefit analysis, because that is the way the second half of a rule is written in the Federal Register. But first principles matter. America was founded on the belief that people should be trusted to govern themselves. Citizens sit on juries and decide the fate of fellow citizens. Voters elect representatives to their state houses and to Washington. By the same token, Americans should be trusted to exercise individual choice and have liberty to make decisions about the way they live their lives. At a practical matter, this means Washington should regulate only when necessary. Certainly, there's an important role for government, particularly when issues of health and safety are concerned. But limiting the scope of government protects space for people to make their own judgments about what is best for their families and for their lives. Those of us in government took an oath to uphold the principles that underlie the Constitution. Underlying those principles, underlying a commitment to the rule of law is an assumption that we should and must exercise great care when we use law, or for that matter, rules, to restrict more than necessary life, liberty, and the pursuit of happiness. So let me just say what a privilege it is to be here at the Federalist Society, to be among friends, and I appreciate your time. Thank you very much.
Secretary Acosta can take a couple of questions. We have enough time, so if there's anyone in the audience who has a question, I would invite you to step to the microphone. Yes, sir.
Secretary, thanks for all you're doing. One of the latest trends in litigation to try and obstruct what you all are trying to do is when you revoke things that were not adopted after the notice and comment procedure mandated by the Administrative Procedures Act. Various departments are now being accused of themselves violating the Administrative Procedures Act before they revoke those illegal guidance memos. I don't know if that's hit your department yet, but how generally do you think the administration is going to respond to those type of claims?
So it's long been the case that there's an attempt to use the courts to make policy. And the reality is that whenever you're involved in rulemaking, litigation, I don't want to say is certainly expected, but it would be someone that does not expect or is not thinking about potential litigation probably is not being an effective lawyer in the rulemaking space. And so I'd say, look, I mean, lawsuits are going to come. The Department of Justice is very good at defending the government. The Department of Justice defends the government regularly, and it is what it is. Yes.
Thank you, Secretary Acosta. Alan Grossman. You have said liberty, pursuit of happiness, some freedom of contract. The President has announced that he would like to have infrastructure programs in place. What is the department thinking of relative to Davis-Bacon, and whether that would be helpful in terms of adding infrastructure to our country?
Well, the President's infrastructure bill will be released in its own time by the White House. And obviously, it's something that's going to have to be addressed by Congress when that infrastructure bill is in fact released. Thank you very much.
Thank you.
Testing, yes. So we'd like to now follow up with going through a more discussion of particular agencies within the department. And it's my pleasure now to introduce individuals responsible for those agencies. First, beginning with Victoria Lipnic, who is the acting chair of the U.S. Equal Employment Opportunity Commission. She was born in Carrollton, Pennsylvania, and graduated from Allegheny College and George Mason University School of Law. In 2010, the United States Senate confirmed her as one of the Republican EEOC commissioners, and she was confirmed for a second term in 2015. From 2002 to 2009, Chair Lipnic served as the United States Assistant Secretary of Labor for Employment Standards, where she oversaw the Wage and Hour Division, the Office of Federal Contract Compliance Programs, the Office of Workers' Compensation Programs, and the Office of Labor Management Standards. She also worked for the United States House of Representatives as Workforce Policy Counsel to the Committee on Education and the Workforce. Before her work in Congress, Chair Lipnic served at the United States Postal Service as in-house counsel for labor and employment matters. She also served as Special Assistant for Business Liaison on the staff of then United States Secretary of Commerce Malcolm Baldrige. And immediately prior to her service on the EEOC, she was of counsel at Seaforth Shaw, LLP. At the EEOC, Chair Lipnic has been integral to the Commission's development of regulations under the ADA Amendments Act of 2008. From 2015 to 2016, she co-chaired the EEOC's Select Task Force on the study of harassment in the workplace. When Victoria Lipnic was named the acting chair of the Commission in January of this year, her appointment was applauded by many. As one commentator put it, she understands the needs and concerns of all the various stakeholders in what can be a very contentious topic. Please join me in welcoming EEOC Chair Victoria Lipnic.
Thanks very much, Your Honor, and thanks so much to the Federalist Society for inviting me to be with you, and thanks to my friend Tammy McCutcheon for inviting me. So in the brief time that I have, I'll give you as an update on things at the EEOC, both in terms of personnel and policy and where things may be headed. But I do want to first say that I want to associate myself with the comments from Secretary Acosta and his approach to rulemaking and the regulatory process generally. I serve and have for the last 7.5 years on a bipartisan commission. The EEOC is a 5-member commission. All members are appointed by the President and confirmed by the Senate. I am currently the sole Republican at the EEOC, and that has been the case for this entire year. So we are currently a 4-member commission. I'm the acting chair of the commission, and I have 3 colleagues, all of whom are Democrats, including Jenny Yang, who is the former chair under President Obama, Charlotte Burrows, who is a very experienced civil rights lawyer from the Justice Department, and Commissioner Heifeld-Bloom, who brings a long history of civil rights activism on disability and was a law professor at Georgetown Law School before joining the commission. I tell you all that because in terms of things that can be accomplished at the Commission, it takes votes to do things. And so the chair has a number of powers. You're responsible for all of the operations of the agency and have a fair amount of authority there. The chair can decide what gets put in front of the Commission to work on and to vote on, but let me say again, it takes votes to change things. So in the time that I've been there, a couple things that in this past year, one thing I want to mention, just as an operational matter, and I know there are many people in this room who practiced before the EEOC. From the time the EEOC opened its doors in 1965, it has had a backlog of charges of discrimination that it is processing. And that has gone up and down over the years. When I joined the Commission 7 years ago, there were about 100,000 charges in the backlog. We put a lot of attention on that this year just as an operational matter, and the Commission will have, just in the past year, see the most significant reduction in the backlog in 10 years. And much credit to our field staff for all their work on that. But this is about a 16% reduction. So and that takes a lot of strategy and effort and, quite honestly, support to the field staff to accomplish that. So part of my message to them was make decisions. Make decisions about these things, and I will support you. So that's just on the operational front. In terms of policy, a couple of things that I wanted to bring to your attention. In the last, month and a half, we have been living in the sexual harassment moment. And I can tell you at the EEOC, since we enforce Title VII of the Civil Rights Act 30 years ago, the Supreme Court decided in the Moderator Savings Bank case that Title VII, by its terms, that you cannot be discriminated against because of sex, that covers sexual harassment claims. So the EEOC has been the enforcer of the law in this area in workplaces. And for the last 6 weeks, we have just been all sexual harassment all the time. I keep reading in various news reports, I've been interviewed by a number of news outlets, and they will say, and she's an expert in sexual harassment. And I kind of think, I'm not sure I like that formulation, so. Anyway, but I mentioned this partly because also a year ago, actually on the anniversary of the Moderator Savings Bank case, one of my colleagues on the Commission, Commissioner Feldblum, and I had co-chaired a select task force on the study of harassment in the workplace. We impaneled an outside group of experts because at a leadership level at the Commission, we were very frustrated about the persistent number of claims of harassment that we get and the pervasiveness of it across industries, from the boardroom, the executive suite, to the factory floor, to the farmer's field. So our report, we made a number of recommendations about things that we thought employers and organizations could do to improve their activities from a prevention standpoint, not just from a legal liability standpoint. We were very critical of a lot of training that has taken place in the cottage industry of workplace training that's developed over the last 30 years. We thought there need to be a number of new approaches in that area. We suggested, for example, there might need to be some efforts about bystander intervention training, which we were borrowing, borrowing that concept from college campuses. And we talked about how there needed to be workplace civility training, which I'm hoping that my friend at the National Labor Relations Board may help me out there and cooperate a little bit in terms of getting the NLRB to agree with the EEOC about the need for civility in workplaces and how employers should be able to discipline employees if they don't comply with the corporate civility code. So just a thought there, Phil. But this has been, it's a big topic. I hope that we actually have a guidance document that we've sent over to OMB for review that would update a number of old EEOC guidance documents related to harassment. And if I see Naomi Rao around here, I'm going to ask her if I can get that document sprung from her. But that's something that's been a big topic. The other thing is wellness regulations. For those of you who deal with employee benefits plans, the EEOC has jurisdiction over wellness plans via the Americans with Disabilities Act. There's a provision in the ADA which says that a covered entity may conduct voluntary medical examinations, including voluntary medical histories, which are part of an employee health program available to employees at that work site. So, since the ADA has been around, that language has been used since 1990 for the EEOC to exert its jurisdiction over wellness plans. Wellness plans were the one part of the Affordable Care Act that had bipartisan support. They were endorsed by Republicans and Democrats. Unfortunately, Congress did not deal with this tension between the Americans with Disabilities Act, what constitutes voluntary, and the incentives that Congress wanted to put in for wellness plans. So that has been an issue at the EEOC for many years. The commissions dealt with it in fits and starts through opinion letters, through sub-regulatory documents. Finally, the commission issued regulations at the end of the Obama administration. In full disclosure, I voted against those regulations. And as the question earlier about agencies and the rulemaking process and expecting lawsuits, we were promptly sued by AARP. They asked the district court judge here in D.C. to issue a preliminary injunction. He declined to issue the injunction. However, he did remand the rules for reconsideration by the agency. He did not vacate the rules, however. And this creates an issue for those of you who deal with insurance plans or employee benefits, because there is a long lead time for insurance plans for when employers have to get those plans in place. So we are in the open season now for people choosing their health care plans for next year. AARP went back to the court and asked them to reopen the vacator issue. They want the rules to be vacated by 2018. We, the EEOC, have proposed put a scheduling order to the court. We said we would do a new notice of proposed rulemaking by August of 2018 with a potential final reg by October of 2019. Any way you cut it, the EEOC will be spending another few years on wellness plans. God save us. So, the civil rights issue of our time. So, one way or another, regulations, sub-regulatory, these things, we spend a lot of time on these things. One last thing I'll mention, because I know, just to be conscious of the time here, I call it a regulation that was finalized at the end of the Obama administration, has to do with enforcement in the equal pay area. The EEOC enforces the Equal Pay Act, and we also enforce the provisions of Title VII of the Civil Rights Act, which would not allow for disparities in compensation, discrimination compensation. And of course, issues about studying the wage gap and ways to address the wage gap, to make a bad pun, have a lot of currency right now. And so for many years, there's been a proposal in Congress to direct the EEOC to do some type of pay data collection where it asks employers to submit their compensation information to the EEOC. The rule that was finalized at the end of the administration, which is known as the EEO1 form. So all employers who have at least 50 employees have to submit an EEO1 form to the EEOC. That is a profile of their workforce broken down by occupational categories and then by race and sex. What was added to the EEO1 reporting requirements at the end of last year was that employers would have to submit their compensation. So their entire compensation system, they would have to fit it into reporting on the EEO1 form. That was called Component 2. Again, full disclosure, I voted against this proposal. It was finalized. It was finalized not through a full-blown rulemaking, but under the auspices of, wait for it, the Paperwork Reduction Act. So the Paperwork Reduction Act is a bit of an odd statute because OMB administers the Paperwork Reduction Act. So in February of this year, this was going to impose a lot more, any way you cut it, a lot more reporting requirements on the employer community to have to submit this information. At the beginning, I think it was in February, the U.S. Chamber of Commerce filed a formal petition with the Office of Management and Budget asking them to reopen their prior approval of this pay data collection under the EEO1 and to review their burden analysis and to review it, which in the area of the jurisprudence on the Paperwork Reduction Act, of which there is not much, this is all sui generis. So OMB reviewed it and they sent it, in August, they stayed the effectiveness of this pay data collection, the Component 2 part of it. It was critical that they make a decision on this because employers were about to have to spend, by the end of August, start spending a lot of money to comply with this new reporting requirement. They were going to have to make major systems changes to their human resources systems, their payroll systems. So OMB stayed it under their authority under the PRA. They sent it back to the EEOC, and that's where it is now. And once we have a complement of new commissioners, President Trump has 2 nominees to join the commission. Janet Dillon, who will be the new chair. She comes to us from Burlington Industries, where she was most recently general counsel. The other nominee, Daniel Gade, who is an Iraq War veteran, former professor at West Point. They are awaiting their Senate confirmation right now. And what will happen with some version or no version of the EEO1 pay data is something that we will also be spending a fair amount of time on. And I should add also that just yesterday we were sued about this. So, and we were sued about this by one of the advocacy groups, the National Women's Law Center, which, as you might imagine, was very much in favor of the new reporting requirements. And as best I can determine, and I have not looked at it that closely, but in their complaint, they seem to be suggesting that we did not follow the Administrative Procedures Act. So all along I kept saying, shouldn't we be doing this as a rule? Why are we doing this under the Paperwork Reduction Act? And we seem to have come full circle on that. So,
thank you so much. Our next speaker is Philip A. Miscimarra, who is chairman of the National Labor Relations Board. Chairman Miscimarra grew up in Pittsburgh and received his undergraduate degree at Duquesne University. He earned his MBA from Wharton Business School at the University of Pennsylvania and also received his law degree at Penn. The United States Senate confirmed Chairman Miscimarra as an NLRB commissioner in 2013. He previously practiced law as a partner at Morgan, Lewis & Bockius and was a senior fellow in the Center for Human Resources at Wharton. Before joining Morgan Lewis, Mr. Miscimarra practiced law at Seyfarth Shaw, Murphy, Smith & Polk, and Reed Smith. Commissioner Miscimarra is also the author or co-author of several books involving labor law issues. Rarely does one's employment history begin at the top. Now, I believe this is true, but I understand you began work as a caddy at the age of 14, followed by work at a movie theater and then the local Carnegie Library. and for many years you worked as a musician represented by the American Federation of Musicians.
Local 6471.
So he knows from a variety of perspectives how labor earns a living. When President Trump appointed Mr. Miscimarra to lead the NLRB, many praised the choice. One experienced observer described him this way: he's very smart with a practical way of analyzing board cases that keeps in mind real-world implications of board decisions on employers and employees. Please join me in welcoming NLRB Chairman Philip Miscimarra.
It's a privilege to be here with Judge Bush and my friends Vicki Lipnic and Nick Geale. I'll make a few remarks about the NLRB. And first, please join me in acknowledging and congratulating my friend and colleague, Bill Emanuel, who's seated right in front of me, who became the newest member of the National Labor Relations Board on September 26th, 6 weeks ago. With Bill's swearing in, the NLRB returned to its full complement, which is 5 members. We currently have 3 Republicans for the first time in 8 years and 2 Democrats. This is a very important transitional year for the NLRB. We are experiencing between January 1st of this year and December 31st of this year, we will have experienced turnover involving 3 of the board's 5 members and the commencement, hopefully this week, of our newly confirmed General Counsel, Peter Robb. And I can't comment on what the board may decide prospectively, but there's no question about the amount of change that has characterized the NLRB's decisions over the past 8 years. And I'll just give you a few examples. I appreciated very much Secretary Acosta's remarks about regulations, because shortly after my commencement at the board in 2014, the board adopted a new set of regulations that changed nearly all of the procedures governing union representation elections throughout the country. And our election rule, when it was released, consisted of 732 pages. I've been told the best part started on page 494, where one could find the dissenting views of former board member Harry Johnson and myself. And in our dissenting views, in the first or second paragraph, we characterized what the board adopted as the Mount Everest of regulations. We said it's massive in scale and unforgiving in its effect. The next day, the National Law Journal had on page 1 a headline that said, NLRB adopts Mount Everest of regulations, and there is a picture of Mount Everest right under the headline. So, at that point, I had been relatively new in Washington, D.C., but I concluded if you said anything on page 494 and it made the headline with a picture the next day, you at least made some modest difference in at least the dialogue. And what the board has done, both in that area and other areas, at least for the past 6 to 8 years and throughout my tenure on the board, has been to introduce very significant change in many fundamental areas of law involving the National Labor Relations Act and management labor relations. In addition to changing nearly all of the procedures governing union representation elections, the board has invalidated in union and non-union work settings many facially neutral work rules and employment policies and employee handbook provisions, including, for example, rules that require employees in an acute care hospital to foster harmonious interactions and relationships with one another. I suspect this starts getting into the area where we have been severely criticized by the people who I thought were my friends at the EEOC. But the board increasingly, in a large number of areas, has found a variety of employment policies and work rules that talk about maintaining civility in the workplace. We have found those to violate our statute because, in fact, employees do have a protected right to engage in various types of activity for mutual aid and protection, even if there are some instances when those protected activities may involve some level of confrontation or adversarial discussion in the workplace. But nonetheless, we've had a broad sweep in cases that have eradicated many common sense standards regarding civility in the workplace. In a range of decisions, and Secretary Acosta mentioned this area as well, the board has redefined who constitutes an employer for purposes of collective bargaining under our statute, who constitutes employees for purposes of union representation, and who constitutes independent contractors, which Congress expressly excluded from the definition of employee when amendments to our statute were adopted in 1947. The board, in a number of cases, has permitted and protected on-premises work stoppages and protests in the workplace. We had one case involving Walmart where a group of employees stopped working and occupied the customer service counter in a Walmart store during store hours when customers were present. And the board majority in that case, and I dissented, the board majority in that case found that that was protected conduct, and Walmart violated federal law by warning employees that they shouldn't engage in the same conduct again. A significant number of board cases has had a very significant impact restricting the conduct of employers during workplace investigations. And in one of the cases, called Banner Estrella, the board majority, again, I dissented, found that the employer violated our statute by requesting employee participants in an investigative interview to keep the subject matter confidential while the investigation remained incomplete. And again, my colleagues found that merely requesting confidentiality for the period of time that an investigation remains incomplete is a violation of federal law. Now, I recall that the EEOC has some regulations that require employers to foster confidentiality during workplace investigations. And one of the things that I believe is an undercurrent in both the EEOC regulations in this area and what I have expressed mostly in dissenting opinions should be a guiding standard for the NLRB when dealing with workplace investigations is that all employees and unions and employers benefit from having workplace investigations into serious subjects that have a high degree of integrity and effectiveness. But nonetheless, the board in this area and a number of other areas has introduced very significant changes in the law in the past 6 to 8 years. The one area that I will also mention without getting into details is the board in recent years has also adopted a significant number of changes in the rules of the road that govern collective bargaining and labor management relations in workplaces where employees are represented by unions. And this is an area in particular where it's very important for employers and unions and employees to be able to tell beforehand what they need to do and what they're prohibited from doing in order to comply with applicable legal requirements. And one of the outgrowths of many of our decisions, especially decisions which have changed the rules of the road, is I fear that we have made it more difficult for all of the parties to figure out for themselves the difference between what our law requires and what our law prohibits. And I think one of the fundamental responsibilities for the board in every case is to try to do what we can to provide guidance to parties who want to comply with the applicable legal requirements. And one of the saddest things that has characterized many of our decisions, and I'll say this, notwithstanding the best of intentions, many of our decisions in recent years have increasingly used exceptions and rebuttable burdens and the opportunity for parties to prove special circumstances that have really made more and more NLRB decisions use the language of lawyers. No offense to anyone in the room who might be an attorney. We use the language of lawyers more than we use the language of real people in the workplace. And I think that's been unfortunate, and it poorly serves the people that our laws and our decisions are aimed at protecting. So at the present time, my term as chairman, I should add, ends on December 16th, 30 days from now. I apprised President Trump approximately 3 months ago, although I'd been encouraged to accept a reappointment as chairman of the board, personal circumstances prevented me from accepting a reappointment to a new 5-year term. If some of you are wondering what the personal circumstances are, they have names: Andrew, Eric, and Joseph. My 3 sons, for inexplicable reasons, all 3 of them want to go to college. They will all 3 be in college for what would have been 4 of the 5 years associated with any reappointment. So come December 16th, I will wake up in the morning, and for the first time in 35 years, I will have no idea what I'm doing the rest of the day. I have no idea how I'll be supporting myself prospectively. But between now and then, we're going to be very busy. And myself and my colleagues at the NLRB, including Bill Emanuel and our new member, Marvin Kaplan, who's also a Republican, and my other 2 colleagues, Mark Pierce and Laura McFerrin, we have a lot of work to do. We're going to continue to do that work, certainly in the next 30 days through the end of my term and into 2018 and beyond. Thank you.
Thank you, Chairman Miscimarra. The last speaker on our panel today is Nicholas Geale. President Trump appointed Mr. Geale as Deputy Solicitor of Labor in February of this year, and Mr. Geale became Acting Solicitor of Labor in accordance with federal law. He also serves as the Chief of Staff for Secretary Acosta. Mr. Geale previously served as a member of the National Mediation Board. He also served as Director of Oversight and Investigations for Ranking Member Lamar Alexander on the United States Senate Health, Education, Labor, and Pensions Commission. Before becoming Director of Oversight, Mr. Geale served as Oversight and Investigations Counsel on the Committee for Ranking Member Michael Enzi. Mr. Geale also has prior experience as service in the Department of Labor as attorney in the Office of the Solicitor and counselor to the Deputy Secretary of Labor. Before his government service, Mr. Geale worked in public and private practice, including serving as Assistant General Counsel for the Washington Metropolitan Transit Authority and as an associate at Thalen, Reed & Priest, LLP. Mr. Geale was graduated from Claremont McKenna College and Georgetown Law. Soon after his appointment to his current position, Mr. Geale was reported to have said that he would, quote, listen to the regulated community a little more from a position of, quote, a little bit more humility. Listening to the governed and serving with humility. Those are important attributes for public service. Please join me in welcoming Solicitor of Labor, Nicholas Geale.
Thank you very much, Your Honor. I will echo my colleagues on the panel's statement that it's really a pleasure to be here at the Federalist Society. I've been a member since I went to Georgetown back in the early 90s. I won't divulge anything further to protect myself. Anyway, also, I want to say it's an honor to be on this panel and to follow Secretary Acosta. He's more of the Shakespeare. I kind of write the user manuals at the Department of Labor, so for what it's worth, it won't be quite as philosophical and engaging, but I'll try to give you an outline on what's going on at the Department of Labor. I will also continue with the theme of criticizing the NLRB, which seems like every speaker has engaged in as well. And I will also note that my colleague to my left, Vicki Lipnic, worked at the Department of Labor during the Bush administration, and she was the last Assistant Secretary for the Employment Standards Administration. She was so good they abolished the position after she left. So to begin with, and just to start off right with criticizing the NLRB, there's a great case that came down earlier this year in the DC Circuit, 3-0 decision, ABM. I recommend it to all of you for a couple reasons. One of which is that they reversed the NLRB's assertion of jurisdiction over airline subcontractors. And they also reversed the NMB's decision in ceding that authority to to the NLRB to do that. And my favorite part about the case is the fact that I'm glowingly cited by the judges for a page and a half. So I recommend that to you highly for that purpose, if no other. With that said, this administration has made putting Americans to work in good jobs its highest priority. At the very heart of that mandate is to ensure that American workers have good jobs and that employers compete on a level playing field where the rules are known, and as Chairman Miscimarra outlined, we need to make sure that the rules of the road are fair and known to all. When we undertake this mission, we got to ask ourselves, what is a good job? Is a good job one where employees are injured or killed, that they lack safety protections? As the Secretary noted, health and safety is an important aspect of our charge from the United States Congress and something that we really, really mean when we say it's important to maintain safe and healthy working conditions under the Occupational Safety and Health Act and the Mine Safety and Health Act. Is it a good job when employees pay their hard-earned money into a retirement system only to find that it's vanished after a trusted fiduciary uses all of the assets in the retirement account as his personal bank? I don't think so either. Is it a good job where employers refuse to pay wages properly owed? No. Is it without a doubt with these scenarios are the antithesis of what we believe in and I think the values that everyone in this room shares? Many of these challenges can be addressed, as Secretary Acosta noted, by ensuring that regulations do not interfere with an employer's ability to provide good jobs to American workers. But today's DOL is also committed to ensuring that employers play by the rules, seeing that they do not profit at the expense of their employees' health, safety, or economic security, and they cannot undermine their competition by engaging in unfair employment practices where other employers abide by the rules. As Secretary Acosta pointed out, these are primarily economic analysis, but they are also our values, and philosophically, freedom and freedom of contract is a high priority, but also our values of ensuring that the law is fairly enforced across the board. Let me tell you about a couple cases that came down this year that the Solicitor's Office was involved in prosecuting. And these are cases where I think everybody in this room can agree this should not have happened, and it is a necessity that there be firm and fair enforcement. First, let me tell you about a case up in New England. In 2016, a case called Atlantic Drain. But let me give you some background on this situation before I get into specifics. In 2016, 23 workers were killed and 12 others were injured in trench collapses. 23 people arrived at work for the day to complete projects in a trench, spanning from 5 to over 20 feet deep. Due to inadequate or non-existent cave-in protection, these 23 American workers lost their lives. In one abbreviated moment, they were crushed and suffocated. People just wanted to do good work and take home an honest pay. They were lost tragically and unavoidably. This has been a problem that the Department of Labor has been focused on for 40 years, and it continues to this day, and we need to make sure that we do everything we can to prevent these sorts of instances from happening. The remedy here was not to eliminate trenches. The remedy is simply to make sure that the employees are safe when they're in the trench. This is something good employers have been doing for decades and something everybody knows or should know how to do. But we will have to pursue cases like Atlantic Drain. On October 21st, 2016, 2 workers were tragically killed when 12 feet of deep trench where they were working collapsed on them. They were engulfed in mud and water and died. An OSHA investigation determined the employer had not even provided basic safeguards against the collapse and didn't train any of its workers with regards to this issue. They failed to install support systems, remove employees from the hazard when they recognized it, provide a ladder to even escape if they'd had even an opportunity to get to it. Basic protections, limited cost, yet each individual item could have saved lives. After this accident, OSHA issued a total of 18 willful, repeat, and serious and other than serious violations of workplace safety standards to the employer, and a proposed fine of $1.5 million in penalties. We also work closely with the Boston Police Department Homicide Unit and the Suffolk County District Attorney's Office in this case, and in February, a Suffolk County grand jury indicted the company and its owner for 2 counts of manslaughter in connection with the death. We have an obligation to pursue these sorts of cases, and I think it's a fundamental responsibility of the department to continue to do these sorts of things and to make sure that every worker can come home, or at least expect to come home every night, safe and sound. A high priority for this administration is also H-1B enforcement with regards to temporary non-immigrant labor. On April 18, 2017, the President issued Executive Order 13788, called Buy American and Hire American. As a result of the executive order, the department announced its intent to protect U.S. workers from program abuse by providing greater transparency and oversight. When used properly, the H-1B program allows employers to hire highly skilled foreign workers in specialty operations. However, in recent years, some employers have used the program to hire foreign workers despite American workers being qualified and available for work, or even to replace American workers and force the American workers to train their replacements. The President's executive order directs federal agencies to review all non-immigrant visa programs and propose new rules and guidance to eliminate fraud and abuse as part of the initiative Protect U.S. Workers. The department is strongly committed to using its existing authorities and has taken action to combat abuse and enhance transparency and oversight. As part of this, the department has begun the process of amending a particular form. Chairman Lipnic referred to the Paperwork Reduction Act, which is kind of a misnomer. I think the Paperwork Reduction Act actually creates more paperwork generally, but for what it's worth. The new form will collect additional information and clarify employer obligations under the labor condition application, increase transparency to ensure we know exactly where the worker will be working, and require the employer to disclose additional information, including if they're using a master's degree, they will have to provide evidence of the master's degree. And I'd also like to talk about another case that I think is an area where everyone in this room shares the importance of enforcing these sorts of rules. There's a case that ultimately was resolved earlier this year involving some brothers named Leon and Carl Wayne Jones and several other intellectually disabled men by a company called Work Services. The Jones brothers were disabled, but they were also very proud and they were very hard workers. When they were young, they were removed from a Texas institution and taught how to catch and hang turkeys by Henry's Turkey Service. After Henry's trained the brothers, they were shipped off to Iowa, where they worked for a few years side by side in a turkey processing facility. Then one day, without warning, without consent, and without any change or notice to anyone, one of the brothers was sent 1,000 miles away to a different location. Although separated, the brothers worked in wretched conditions and without receiving a single paycheck of their own. They were literally paid in chips and other snacks for some period of time, according to the determination of the Department of Labor. They just wanted to do good work. And ultimately, the department filed suit against the company on behalf of the workers, alleging wage theft and violations of record-keeping provisions under the Fair Labor Standards Act. Ultimately, the court awarded disabled workers back wages of $82,000 and liquidated damages in an equal amount. This is just an example of the type of important enforcement actions, again, that need to be undertaken by the department. I want to talk a little bit now about some interesting cases coming up in the Supreme Court. As the Secretary mentioned, we have some challenges to the tip credit rule that are pending before the Supreme Court. But there's another case that will be of substantial interest to everybody probably in this room. It's called Janus versus AFSCME. The brief for the petitioners will likely be filed sometime in the next couple weeks. It's been delayed once already. And certainly there is great interest in that case in this room, and I know amicus briefs will be filed some point thereafter. And previous case that that dealt with the same issue was decided 4-4 in the Supreme Court, unfortunately, after the untimely death of Justice Scalia. So this is a revisitation of that issue and certainly will be of great interest, and obviously it deals with labor issues involving union fee payers in public sector positions. So I think that's a very interesting case that will be coming shortly. The last thing I want to do is the Secretary outlined the regulatory, deregulatory actions that were fundamentally involved in sort of a liberty perspective at the department. But I want to just give you a brief sketch of the scope of what we're looking at right now more broadly. In addition to the ones that he outlined, as I mentioned, we have the Paperwork Reduction Act changes to the H-1B forms. We've done some look at H-2B reform, and we're looking at association health plans. An NPRM was sent over to the Office of Management and Budget just this week. All you can see is the title, but that's currently being looked at by the Office of Management and Budget. The fiduciary rule, a final rule entitled 18-month delay to the prohibited transaction exemptions, is currently pending over at the Office of Management and Budget. We are working and addressing a disability insurance claims rule from the prior administration. That went through a notice and comment period, and we're looking at a final rule on that shortly. Some changes to the metal non-metal rule for the Mine Safety and Health Administration have been proposed already. The Secretary discussed the persuader rule. We also have some changes to a beryllium rule from the prior administration with regards to some ancillary provisions that deal with the shipbuilding and construction industries. The tracking of workplace injuries and illnesses rule has been proposed on that. Crane operator certification. One of the first things that the department did after I came on board in the early part of this year was withdraw an interpretive letter on OSHA's walk-around procedure, allowing non-employee union representatives to accompany OSHA personnel on inspections at non-union facilities, rather. As you may know, we are in the process of looking at the prior overtime rule that was enjoined by a federal court. We published a request for information earlier this year. We received 214,000 comments, so it's going to take a little while to determine exactly what direction we're going forward with that. And we also have implemented a congressional mandate with regards to the Hire Vets Medallion program, where we recognize employers who are doing a great job in hiring veterans. That's not even everything that's on the list. But that's just what we've been up to in the last 6 to 9 months, and we're just getting started. So with that said, it's an honor and a pleasure to be here. It's really a pleasure to be on the panel with my two friends, Phil and Vicki. And I am very pleased to be here with you and happy to take some questions from the Honorable Judge Bush.
Thank you very much. So we are going to open this up for questions from the audience, but as you can just go to the mics. But and just asking one question I have from this morning, Senator Cotton talked about the delays in the confirmation of new appointees to various agencies, and that the difficulties that has created. And I'm just wondering, from the perspective of the Department of Labor, EEOC, or NLRB, whether that has affected your operations in any way, the delay in confirmation of new appointees.
It certainly has an impact. One other position that I forgot to mention is that the President will also nominate a general counsel to the EEOC, and there is not yet a nominee for that position. And that's a very critical position at the EEOC. The general counsel is responsible for the conduct of litigation. So I will say this, the EEOC has a long history of doing its best to work in a bipartisan fashion, and my colleagues that I am there with, we are a very collegial group. But in terms of if you want to change policy or things, it makes a difference if you don't have the votes to do it. So where we can, we do everything we can to work in a bipartisan fashion.
So Only yesterday did we get our second confirmed political appointee at the U.S. Department of Labor, and that's the Assistant Secretary for the Mine Safety and Health Administration. There's no Deputy Secretary. There's no one else in any other confirmed position. As you saw from my list, that hasn't stopped us from getting a heck of a lot of things done. But certainly, it would be very beneficial for our ability to move quickly and to address really urgent issues if we could get our folks confirmed.
And I'll just say that I'm still basking in the happiness of having 5 confirmed board members as of the past 6 weeks with Bill Emanuel's arrival at the board. So I'm not complaining, but I will note that throughout the history of the board, both Republicans and Democrats have all claimed that the board functions best when we have 5 members on the board. And so we ended up having 1 vacancy on the board that was not filled until August, and the seat had been vacant for 2 years, and Bill's seat had been vacant for 1 year and 3 months. And it certainly would have helped the agency had it been possible to have 5 confirmed board members much earlier in the year. But you know, I'm happy where we are right now, but it certainly would have helped the NLRB's functioning to have a full complement of board members sooner than we have.
We're going to take some questions from the audience now. Sir, if you could ask your question, please.
Okay. Thank you all for being here. Very encouraging to hear the direction that you're pointed. I've been in-house for a number of years. Last 8 years with the company, we have about 4,000 employees, a couple dozen manufacturing facilities around the country. 8 years ago, I probably got pulled into labor and employment matters occasionally. Now I spend anywhere from a third to half my time on them. And it seems like we went through 8 years of really hostility towards employers. And with the frontline people we dealt with Department of Labor, OFCCP, EEOC, NLRB, if not hostile, at least they had very little appreciation for what it means to be in a business or to try to run a manufacturing facility. And so my question is, how do you take the direction at the top and push it down to people who are long-term employees that maybe have a slightly different view of how things ought to operate?
So I'll start with that if you don't mind. The extremely knowledgeable and experienced career employees we work with at the department understand that things change and priorities are focused by the leadership at the agency. As you've probably heard, the Secretary has directed that we focus more on compliance assistance, and those sort of aspects were included in the President's budget as well. So to each side of the equation, there's additional compliance assistant. Employers who want to do the right thing should get help from the government in terms of explaining things clearly and helping them resolve issues if they're relatively minor or if there's some confusing aspect of the regulation, et cetera. I outlined some of the more egregious cases of enforcement. That's where the government's resources are best allocated in instances where there's violations of the law. Coming after somebody who just makes an accidental mistake is not necessarily a good use of the taxpayers' resources. And I certainly think that it's relatively easy to explain that to career staff, that you want to go after people who are acting in an egregious manner and flagrantly violating the law and allocate your resources most effectively in that direction. That's not really something where even somebody who ideologically may disagree with me is likely to fight me particularly hard.
I'll just mention 3 things very quickly. Training, leadership, and support for people in the field. When I mentioned at the beginning, the EEOC has historically had a tremendous backlog, and that has an impact on how people in field offices go about their work and their morale. And support for understanding the circumstances under which they are operating, the resource constraints that they have, and giving them a message that you will support them, I think can make a difference.
And the one thing that I'll add is certainly there's a need throughout our organizations, and our agency is no exception, to try to be more uniform in terms of the work that we do and to help people understand how they can more effectively serve our various constituents. I will say in relation to the NLRB, you know, we're a small agency. We have about just under 1,500 employees. We have every year about 21,000 unfair labor practice charges that are filed. And 95% of our cases have an upfront substantive investigation and are resolved completely, end of case, no right of appeal, within 60 to 70 days after the cases are filed. So to some significant degree, one of the untold secrets about our agency is we have a high degree of effectiveness at investigating and resolving cases which are finally resolved in roughly 2 months after the cases are initiated. But in the 5% of cases that are not resolved that way, we need to do a better job, and in particular, we need to do a faster job. And that's been a very challenging, that's been a very significant challenge for the board. We don't do fast very well, and that's an area where we really need to make a lot of improvement.
Let's take one from this side of the room.
Hi. I'm a law student who worked at the Mine Safety and Health Commission this summer. I was wondering about, I asked a question for the Department of Labor that like President Trump throughout the campaign, and he's been very much about bringing back mining jobs and preventing burdensome regulations from impacting mining. At the same time, mining is an extremely dangerous job. People die all the time or get severely hurt, as I learned this summer. I'm wondering, for proposed rulemaking to try to reduce that regulatory burden, to perhaps increase mining jobs, what way to go about changing mine inspections without compromising on health and safety for miners?
So for those who don't know, under the Mine Safety and Health Act, the MSHRC, Federal Mine Safety and Health Review Commission, is where the Department of Labor prosecutes cases with regards to violations of the Act. The MSHRC is an independent agency. It's a 5-member commission. The OSH Act has a similar concept where there's an OSHRC that has 3 members. The MSHRC also has administrative law judges where cases are tried as well. And so the Solicitor's Office prosecutes those cases on behalf of MSHA at the MSHRC, and decisions are rendered there. Ultimately, they're appealable up into circuit courts, et cetera. For those who don't have an esoteric interest in Department of Labor administrative law processes, I thought I'd at least explain to you what the MSHRC does. So that is absolutely a critical and important issue. How do you determine the difference between excessive regulations and what's absolutely necessary for health and safety? And that's in part where you go through and why you go through notice and comment. You need to be fully informed of the implications of things. You need to understand what the value of the regulation is and how do you weigh that with regards to the safety. Mining is an inherently dangerous task, as you just mentioned. And so we need to make sure, to the best of our ability and in accord with our statutory charge from the United States Congress, that the Department of Labor fully and fairly regulates and enforces the law with regards to mining. Now, a large percentage of the issue with mining being under attack during the prior administration deals with environmental rules, which fortunately the Department of Labor has no involvement with, but I'm sure there's an EPA panel somewhere around here that you can ask some more questions about what they're up to in that space. With that said, I totally appreciate and understand that every regulation needs to be looked at. In fact, the President charged us with that as part of his regulatory directive early in the administration, and we are faithfully and fully undertaking that responsibility to look at these things and to be informed by our stakeholders, all of them, labor and management, employees and employers, to take a look at all these things and figure out ways to do things quicker, better, more efficiently, less costly, but maintain the same level of safety and health to the fullest extent possible.
We have time for just one quick last question from over here, please.
It's quick. Pepper Crutcher, management lawyer from Mississippi. This is for Ms. Lipnic. And funny you should mention training. That's my question is about. I've had 2 occasions in the last 8 years where area office investigators have told me that cause determinations that I didn't think could be supported in current law were based on training that the investigators in the offices had received. And when I recently asked what training, I was referred to a PowerPoint slide deck. Is Is it possible under the current structure for training to override legal guidance from EEOC attorneys? And could it really be that cause determinations get made based on PowerPoint slide decks?
I hope not. I'd be interested to hear more about that.
Well, thank you so much, all of you today.